reason being, so much was going on in the contract and added to the contract that we actually spread it out over 16 pages. One of the reasons why that's 16 pages is that the RCSD is no longer needed if the contract's properly filled out. So along the way, we're trying to eliminate forms as well. I will share with you that I'm a working manager here at Century 21 Care and Diamond Bar, so I see contracts usually every day. I will give you an overview of my feelings since we started using the contract in December on the 14th that actually began being used. We're not seeing a lot of problems. I saw many, many more problems using the old contract. We are seeing more detail being placed in the grid area that was required before but wasn't being utilized properly because the contract had items spread out, where we've now concentrated into the pretty much first 3 and 4 pages for items that get filled out in the contract. So before we go any further, is there any questions before we get started? Anything somebody wants to mention they want to make sure they hear about today, or any question? Okay, seeing none, I'm going to proceed. We would like to see you if we could possibly see you. If you have a camera, turn it on. We'd like to see your faces and while you're listening to the sonar. We love it. So let's talk about the new purchase contract. The top of the purchase contract is nothing different. It just has the regular information you get from the multiple listing service. Also, the agency disclosure has not changed. That changed a few years ago, and it updated where you could break down who's representing whom, even if it's within a brokerage. So that didn't change. One of the things I like about the purchase contract more and more as I'm using it is item number 3, terms of purchase and allocation of cost. Hold right there. The items in this paragraph are contractual terms of the agreement. Reference paragraphs provide for further explanation. This form is 16 pages, and the parties are advised to read all 16 pages. I love that that's added, and I also love that it's added again above the signatures of the party at the end of the contract. So it's not only your duty, like you are the smart ones attending class, but it's not only your duty to know this purchase contract, but it's the duty of the client to read it and understand it as well. I'll give you a risk management help idea, what we recommend for you. I actually am the chair of your professional standards committee, and we deal with a lot of risk management issues. And what we would recommend is, prior to sending out any of these documents for signature, to email the clients these documents filled out as they are going to be making their offer, and state in the email, before I send this to you for e-signature, please read, ask me any questions. And when I send them to you electronically, I will also be on the phone with you explaining what you're signing. We're seeing a lot of buyers and sellers going into court and saying they just sent it to me electronically and didn't explain it. So do know the contract, read it, understand it yourself so you can explain it to your clients. So let's talk about the grid. Here's all the meat of the matter, but don't forget that the items in pages 5 and on are just as important and actually create the details of this grid for you. And I'll show you where they can reference from the grid to the paragraph and from the paragraph back to the grid. So 3A would be in paragraph 5, 5B, and if it's a cash purchase, it would explain what a cash purchase is in section 5B. And the terms, the purchase price, terms and condition, that's where the purchase price goes. It goes 2 places on the front page, right here, and of course down the bottom like it did before. So the close of escrow is addressed here right in the front. How many days of an escrow period do they want? Or is it a particular date? Always when you're adding something in the contract and there's a block sitting there, please check the block. because sometimes it'll say this or that. And if you put something on the line, don't check the block. There's confusion. Which did you mean? Did you mean what was printed, or did you mean what you wrote? And by checking the block, the attorneys explain it to us. It's like raising your hand and say, hey, look over here. I've made a change. So if you see something with a line and it has a block, please check it. Expiration of offer, that used to be above the buyer's signature at the end of the contract. It's now moved up to page 1, item 3 on your grid. And paragraph number 32A explains what the expiration of the offer is. And it's going to go to 3 calendar days after all buyer signatures, or a particular date for the expiration of offer, and a specific time, maybe 5 o'clock, or if your seller or buyers want to reduce that time, you've talked to them and they said, well, we can't answer till 9 o'clock that night. You can click the block and for PM or AM, whichever applies, and put the time of the expiration of the offer. Initial deposit, whatever the initial deposit is, actually Zip Forms calculates this for you. So if you put, it's a $500,000 offer and you put 5,000 for the initial deposit, it will calculate the percentage for you at 1%. And then it tells you percentage number above is for calculation purposes, is not a contractual term. If you look over onto the right side of the grid, it has additional terms. And the initial deposit was within 3 business days, or if there's an extension of that or a shortening of that time, you could write that in as the agent writing the offer. And that would be after acceptance. And it defaults now to wire transfer. It did in the other contract, but there was a lot of confusion the way that was written. But here you can see on column 3 under additional terms for 3D1 initial deposit, it is a defaulting to wire transfer. Or if the particular buyer is going to make personal check, you could click the block and write that in there. Increased deposit. There's been a change to this area, and this is 3D2 we're talking about. It's referenced in paragraph 5A2. And if there's going to be a increased deposit, the form that would need to be signed by both buyers and sellers at the time of the increased deposit used to be called the receipt for increased deposit, or the RID. Is now called the DID, and that stands for the delivery of the increased deposit. So the RID is no longer, the DID has taken its place. It's referenced right there in your paragraph. And then the amount in column 3, the amount, column 4, the amount of the increased deposit would be placed there. If there is an increased deposit, we don't see it too much, but if there is, what's important about that DID is if the buyer comes in, puts an initial deposit down, and then they intend to extend that deposit, increase that deposit, if that DID form is not signed, the only claim against a deposit of the buyers the seller would have would be to go against the original initial deposit. So if you're the seller side of the transaction, always make sure the DID is signed by the buyer. So that way, if the seller could claim against the buyer for their deposit, they would be able to go against all monies in escrow up to 3%. Additional terms on the right side, upon removal of all contingencies or whatever date it's set up for that increased deposit. We're going to move on. Loan amount. First, information in here that must be filled out. How much is the loan? If it's 80%, 70%, maybe half, 50%, 3.5%, whatever it is, when you put the amount in the dollar section, Zip Forms will calculate what the percentage of the purchase price is. You can handwrite this contract. So if you're handwriting the contract, you have to figure out what the percentage is. Then in the next area, fixed rate or initial adjustable rate not to exceed. This is where terms are very important in a contract. And this is what, in the past, our biggest pet peeve was no one would put what the max interest rate that the buyer's willing to pay and how many points they're willing to pay. And that's a term that has to be in the contract. So now I'm seeing that agents actually, with it so it's set up this way and so prevalent on the first page, agents are actually bringing in full terms in this section. So that's a good thing with this contract. So, and it's within 17 days after acceptance. Conventional or if checked. So as you see, the new contract refers to the fact that it's going to be conventional or you check FHA-VA. If you're checking FHA-VA, you have to include with the purchase contract the FVAC and the HID. Those familiar with the old contract, remember there used to be an FVA form. Well, the FVA form is no longer going to be used. The FVA form used to say, well, when the appraiser went out, they found these items have to be fixed because it's an FHA or VA loan. That's going to now be in your request for repair. So the FVA form will not be used any longer, but the FVAC and the HID are. The HID is recommending that everybody understands they should get an inspection if it's an FHA, VA, or any type of property and loan. But the FVAC form says that the house has to appraise for the amount that the buyer is willing to pay, FHA, VA. So therefore, if the buyer's buying FVA or VA, they really technically can't waive appraisal unless they're willing to bring in any of the difference. But technically, the FHA, VA have protected the buyers that they can't be out there hanging on a limb and they have to go ahead and pay whatever difference is from the appraisal to the amount that they offered for the property. There may be seller financing involved. That block would be checked, or other type financing. That block would be checked. And you can type in that area in zip forms what type of financing it will be. Might be a private party, whatever type of financing. There's also an additional financing area here. It's referenced. And as you see in the column of the paragraphs, 5C2, if they want to know about more information about the additional financing, they can go to those paragraphs in the contract. We're going to go through those paragraphs a little later. So once again, the same thing holds. What is the interest rate? How much they're purchasing? What is the percentage of the purchase price that the additional financing would be? And they would check. It would revert to conventional, but if it's other financing, they could check it on the additional terms block. Occupancy type, look at this. It refers to the fact that it's going to be their primary residence, and they've added now secondary. It used to just be primary or investment. I'm going to live there or I'm not. And this has been moved to the first page, opposed to section 9 in the old purchase contract. So right up front, the buyer has to declare if they are going to move into the property or if it's a second home, secondary financing for another home or an investment property. The down payment area is there. If you're using zip forms, it calculates for you. And then the total purchase price is the bottom of the page 1. And then make sure your buyers and obviously initial page 1 when you're completing that form. Let's go on to page 2. What we're talking about here is seller credit. Remember, it used to be additional financing terms is where you can put credits. Now it's got its own section. So if the buyer would like the seller to credit money or a percentage of the purchase price to them to close escrow, they could also add it in this area. And then on the additional terms, seller credit to be applied to closing cost or other. I don't know very many lenders that allow credits for anything other than closing cost. So it whatever other would be, perhaps if it's a cash deal, there could be other terms worked out there. Additional financing terms, that would be for whatever additional financing terms the buyer wants to share with the seller. It would go into this area. Let's talk about verification of all cash and sufficient funds to close the escrow. I like the way they have added a lot of these items. Like I said, they brought this contract into today's market. So it's also asking not just for the down payment verification, it's also asking for enough funds to close the escrow. In other words, to include closing cost. So it's either it's going to revert to it's attached to the offer, or 3 days or so many days after acceptance that the buyer will produce that to the seller. Move into, and if they want more information, if you want more information about that particular item, you can go to paragraph 5B. I'll keep referencing back and forth because when you get to those paragraphs, it refers you back to the grid, which you never feel like you're lost in this contract. Verification of down payment and closing cost, verification of the loan application. All of those are going to be attached to the offer. And if they're not, you have to check the block and say when they will accompany the contract to go to the seller. Let's look at 3H3. By the way, on your grid, everything begins with 3, and then it's section H3. So go to verification of loan application and go all the way over to additional terms. Here's where you're going to check. Did you get a pre-qualification? Another a letter that the buyer spoke to the lender, and after their conversation, they got pre-qualified, or a pre-approval, where they've actually sat down with the lender and given them their tax returns and their pay stubs and verification of everything that they need to get a loan approved. Now, the fully underwritten pre-approval is considered, they call that the DU, the desktop underwriting. So depending on where you are in the approval process for your buyer, you need to check it there and let the seller know when you're writing the purchase contract exactly what you're going to be attaching. And it says that in the middle terms and conditions section, you're going to attach whatever it is that you check, it'll be attached to the offer. So there's an area that's intentionally left blank there, but then you're going to see final verification of condition. Well, this was way back in pages in the contract, kind of like page 7 or 8, I believe, the final verification of condition. It's right here in page 2 in the grid, 5 days prior to close, or whatever amount of days you add in there for the final verification of the condition of the property. Assignment. This is something new and different. By day 17, if there's going to be somebody added to the contract, somebody taken off the contract, it's going to be assigned to someone else. This process has to be completed by day 17, or maybe a shorter amount of time. And this is where I'm going to take time to make sure you understand. If it's a short escrow, and this is where I'm seeing a little difficulty with this contract, I have contracts coming in that say it's going to be a 12-day or a 15-day escrow, but I look on page 2 and all the timelines are left as 17 days. Well, if you have a 12-day escrow, how can it be 17 days to prove things or get your loan or whatever the case may be? So you have to shorten those periods of time to adjust it to the length of the escrow. So if it's a shorter escrow period, even 30 days, 17 days might be a lot of time to be giving. You might want to consider if it's okay with the buyer and see if it gets approved by the seller when they look at the offer, that it remains 17 days. It might be a little long. I have seen a lot of agents writing 5, 10, 12 days into these areas. So think about the fact that you don't want to have an escrow close on day 12 and they have till day 17 to release a contingency. It just doesn't make sense. So let's talk about the loans. The time to remove contingencies. As you notice, the previous contract on the loan was 21 days. Everything now is 17. Or on the right-hand side of the form, contingency removed, no loan contingency. Could be no loan contingency because it's all cash transaction. However, If there's going to be no loan contingency, I'm going to mention this now. CAR has put out some guides. There is a non-contingent offer guide, and it gives the pitfalls and the pluses and the minuses. It just tells it like it is if people are releasing contingencies upon making a purchase. It's really wise to use these guides. Our company has done something a little further, and we put areas where the buyers and sellers can sign these guides, that at least we've proven that we have given them the guide and the information. There's another one for the escalation clauses. Some of the buyers, for instance, in additional financing terms above, some of the buyers are writing in, we will pay $1,000, $5,000, $10,000 over your highest offer. Of course, the seller would have to show proof that they got an offer for X amount, but the buyer could come in and say, I will pay more than anybody else has given you by a certain amount. That's an escalation clause. There's a CAR escalation guide that has been written by CAR, once again, with the pitfalls, the pluses, the minuses of doing that. So I would recommend please put those in your file. We are expecting a lot of lawsuits in the risk management area. We're expecting a lot of lawsuits from unhappy buyers that were forced, they're going to say by their agent, to overpay for a property in this market. And this is just some protection for your brokerage, that you could have something in writing that you did introduce this information to the buyers and sellers, and they decided to do it anyway. That's taking the pressure and the liability off you and your brokerage. So back to the grid, the loan. So if there's no loan contingency, it could be a cash transaction, or the buyer may feel secure that they're not going to have an issue getting a loan. That means they can no longer use the loan as a reason to cancel at any time. So let's look at the appraisal. Appraisal contingency based upon appraised value at a minimum purchase price, or whatever price the buyer's willing to pay. There's an area there where you can put that amount in. I have heard that a lot of agents are adding under additional financing terms, and there's another area where you can add some comments that the buyer's willing to pay. If the house doesn't appraise, I bought it for $500,000. If it appraises at 480, I'm willing to go up to 490, or pay 5,000 over the highest appraisal, or whatever the terms would be, whatever the buyer's comfortable with. But I would always put an amount. Don't just say we're willing to pay the difference, because that may make the buyer have to come in with a lot more money than what they expect. With the prices rising the way they are so quickly, appraisals sometimes aren't catching up. So if the buyer chooses, they have 17 days to release that contingency after acceptance. And then no appraisal contingency is the block. A lot of times people are checking. And once again, that's a non-contingent offer guide that I would make sure they read and sign and accept prior to have you check any of those blocks. Investigation of property, 17 days. And as you see, there's nothing 21 days anymore. Everything's cutting off at the 17-day mark. And remember, make it shorter if it's a short escrow. Also, informational access to the property. That's something different, something new. Buyer's right to access the property for informational purposes is not a contingency and does not create cancellation rights, and applies even if contingencies are removed. And if you look over to the right-hand side, it says removal or waiver of contingency. There is a block there. They can check that they are releasing contingencies when they're going in. I wouldn't recommend that. The attorneys aren't recommending that, but a lot of the market is demanding that now. A lot of sellers are demanding, don't come at me with any contingencies if you want to buy my house. And unfortunately, we think it's going to lead to some lawsuits, but the block would get checked if that's what they are deciding to do after you give them the guide, and make sure they read it and understand what they're doing when they're checking off no contingencies for investigating the property, and also no contingency for appraisal. Review of seller's documents. The seller has an obligation still within 7 days of acceptance to get all disclosures to the buyer. And I'm going to harp on you about using notices to perform. You need to follow the contract. What is really in a risk management way, very important to understand is upfront, you need to be talking to buyers and sellers about the fact that you need to use notices to perform. If someone can't perform in a timely fashion in the contract, you have to be using extension of time request. And we're not seeing them in a lot of files, and it's creating problems that maybe at the end of the transaction, the seller wants to close and they're putting demands on the buyer. Well, what we're being told by the attorneys who represent realtors in court is the judges are saying, wait a minute, nobody followed any guidelines throughout the transaction. And all of a sudden the seller wants to close escrow because they need their money and they're putting demands on people. Well, wait a minute, why wasn't there a demand when they didn't put their money in escrow on time? Why wasn't there a demand when they didn't release contingencies? What, and so you can't not follow the contract to the end and then decide to follow the contract. You're not going to fare very well in arbitration or court. So follow the contract. And the great thing is it's spelled out. Timelines are spelled out now in the first 3 pages of the contract. It's definite times and expectations of all the parties. So explain to buyers and sellers going into your transactions that these documents are going to be used. It wouldn't be beyond comprehension to on day 1 put a notice to perform on the buyer for their initial deposit. And then on day 4, if the buyer hasn't put business days, of course, if they haven't put their money in escrow, sellers are having 20, 30 offers, maybe 50 offers at a time. Why are they going to be delayed by a buyer not performing right off the bat? They would have the option to cancel if the buyer is not following the contract. But if you put the notice on day 1 and it's a 2-day notice minimum, then you have the 3 business days are already used up. The buyer hasn't performed on day 4. The seller would have the right to cancel the contract. So let's move on. Once again, review of all the seller's documents is 17 days still. Preliminary title report within 17 days, the buyer has to review it and release contingencies, common interest disclosures, review of leased and liened items. This is very important to find out up front for the buyers, and this information needs to get to the buyer by 7 days after acceptance regarding if there's liens regarding their maybe air conditioning systems, water filtering systems, solar panels. All of that information has to be from the seller to the buyer within 7 days. That's calendar days. The only thing that's business days is the earnest money deposit. Now, it does say now, and it changed a few years ago, if those timelines end on a weekend or a holiday, it does revert to the next day. But technically, you're counting every day, except it is business days for your initial deposit. The reason why it's business days because escrow isn't open on weekends and holidays. So it's only business days for that. So if the buyer is selling a property in order to purchase, if you look at 3L8, and the explanation of all this is in paragraph 8J, you would check the block and add the COP, which is a contingency of purchase for it. And it does state that this sale is subject to the sale of the buyer's property. Now that form has got very extensive over time, and it does help that the buyer gives all the information to the seller regarding their contingency, and then the seller can decide if it's something that they want to entertain and take their house off the market for a contingency. A lot of people say in this market, nobody's going to accept a contingency. Well, we've seen a few accept it because they're having difficulty finding replacement properties. So they're putting contingencies on buyers, say this is all subject to me finding a replacement property. So if you notice, all of these items have been taken from all the pages, the 10 pages in the purchase contract, and placed now in a grid at the beginning of the contract. So let's go into possession and time for performance and additional terms. Time of possession. Upon recording, it reverts to like it did in the old contract, or at 6 o'clock on that day, and or more days, which is addressed in the next section here. But I want to make sure you understand that 6 o'clock is there for a reason. It used to be 5 o'clock. The reason it went to 6 o'clock, and a lot of times I'm seeing agents put back in the 5 o'clock. Well, sometimes if it's a recording late in the afternoon, whoever's down at the recorder's office for the title company can't get back to their car in enough time. They may have been at the window at 5:05. They can't get back to their car in enough time to call escrow to let everybody know it did indeed record. So that's why it was moved to 6 o'clock. It gives escrows more time to get the information and pass it on to the buyers and the sellers and the agents, of course. So if it needs to be a different time of possession, you have the opportunity to put the timing there. But some counties do, as you know, record in the mornings only. Some record both morning and evening. So it just depends on what county the property's in. So if you go to the next section, seller occupied or vacant units at the close of escrow, or if checked, up to 29 days. And if you look over an additional terms section, it says use the SIP if it's 29 days or fewer. If it's more, 30 days or more, you have to use the residential lease contract with the purchase contract regarding those additional days. Always check with your lender. We are finding some of the lenders are getting more lenient now and allowing sellers to stay in the property. Because remember, if you go back the page before, it asked, is this your primary residence or is this an investment property or your secondary residence? If it's an investment property and or your primary, the lender is going to be looking at this very closely, because if you say it's your primary, yet you're renting it out to the seller, what is it? Is it an investment or is it primary? So you have to be specific here. So if it's up to 29 days, the best part about the SIP form, we've used it in our company for years now. If the seller stays 5 minutes past close, we want the SIP, because an item they added to the SIP years ago was the fact that seller, if you do remain in a property past the time you're supposed to get out, there could be monetary court awarded damages to the buyer. So, and it seemed to stop the nonsense of sellers saying, oh, well, we closed on a Monday. I wasn't expecting that. My friends can't come till Sunday to move me. So the buyer's just going to have to wait. And here you have a buyer that's moved out of where they've lived. They're sitting with a truck waiting to move in like they were told they could. And now you have an issue and everybody's unhappy and sad at the end of the transaction, when that's the worst time to have issues with a transaction, because obviously we sell real estate to keep these clients for years to come and to refer us to their friends, because it's a smooth transaction, not one with problems. So if you notice, there's a new form that was created for this contract, and it's called the TOPA. It's the tenant in possession. If when you make an offer on a property and there's a tenant in the property for any reason, now, a lot of times my agents will give me pushback and say, but they're leaving this weekend. How do you know that? So any property that has a tenant occupying the property at the time of the acceptance, it is required that you use the TOPA form, tenant occupied form. And you have to check the block that it's going to be attached to the property, and it spells out all the details. Maybe the buyer's adopting the tenant. Maybe they're buying a property for investment and that a tenant is to stay. It will allow the buyer to spell out the information. There's also the RCJC form, which is rent cap and just cause form, that comes attached to the TOPA. Use that form in conjunction with the TOPA. It comes together. That does get completed, and you need to attach it to the purchase contract as well. That's if there's a tenant living in the property. So let's go to documents, fees, compliance, time for performance. The seller delivery of the documents, like I've said several times, is 7 days. Well, what if it's a 12-day escrow? Perhaps the buyer wants to say, no, I want to see all documents within 5 days. And that's where you could put that information. If it's a long escrow, the buyer may say, oh, take 15 days to give me all those documents. Whatever the case may be, you adjust it to the offer that you're making and the circumstances of the buyer and seller. Sign and return escrow holder provisions and instructions. This was buried in about page 3 of the old contract. Well, now it's in the grid and it's standing out, and everybody has to understand you have 5 days to sign and return escrow to the escrow holder their instructions. In other words, their supplemental instructions. And if you take note to this purchase contract and look down at the bottom of this page, it says you are creating the joint escrow instructions. I've had agents come to me, well, we didn't start anything because escrow didn't send us the escrow instructions. Well, you're actually creating the escrow instructions. You have the escrow instructions when you have a contract that's been written and accepted by all parties. They are your escrow instructions. What comes from escrow is a supplement, and that's what they're referring to here. Any items that they send from escrow need to be completed and returned within 5 days. Time to pay fees for ordering HOA documents. The seller, you're telling the seller, hey, you only have 3 days to get those things paid for, because technically the buyer needs to receive them by day 7 if nothing changes on the timeline. Look at this one. This is an interesting one that's been added now, and for good reason. And what I would make reference to in a listing appointment is make sure the sellers understand that the buyer's only going to give them 7 days or maybe less, maybe more, to install smoke alarms, carbon monoxide detectors, and do the water heater bracing. Now, why is that an issue, and why did they put it in the grid? Because what's happening is the investigator, the inspector, goes out to the property and investigates the property, and these things aren't there. So somebody's got to go back, and it's usually that inspector, and there's a fee for that. Everything costs money. So there's a fee for the reinspection. And if you go to paragraph 10B, section 1, if it's where it's referenced here, in the paragraph section, it's going to explain that the seller, you are going to be responsible to pay any reinspect fee if these items aren't there. But what I'm seeing is a lot of times in the inspections, they're being done quicker than the 7 days. So when you take a listing, give the sellers a heads up. Get those things done before the inspector has the chance to come, because you may have to pay a reinspect fee if they're not completed when the inspection's done by the buyer. Evidence of representative authority 3 days after acceptance. We're going to move on. I want to talk to you about items included and excluded. I'm seeing these come in blank, and I'm pretty sure in order to get a loan on a property, there needs to be a stove in the property because the house has to be habitable. That's what I was told by appraisers and lenders. So more than likely there's a stove already there. You should check that. Even if the buyer's going to move in, tear it out and put a new one in, check that the stove is to be there so it'll be there when the appraiser goes in. And anything else, check everything that the buyer wants to have remain. Now, we had a situation where one of our agents had an offer come in on a property, and it said that there's going to be a security system and smart home control devices, and they didn't exist in the property. And I told her, you have to counter that out, because if you leave it in, the seller needs to supply it. So just be very careful when you're writing these things that you're not just checking blocks. Make sure that the items you're asking to remain are actually there at the property. And then if there's any additional items included. If you go to section 9 in the purchase contract beyond the grid, you're going to see that it addresses all of these items, plus talk specifically about what the seller has to have remain. When we get to that paragraph, I'll point out some things that they added since the new contract came into play. Now, things included are very important. So if there's items that maybe in the MLS, they said the washer, dryer, refrigerator is going to remain, you've got to write it in the contract. The MLS is not party to the contract. You have to put it here, and that's the area where you would place it. Check the block and put refrigerator, check the block, washer, dryer, if it's not already checked up above. Items excluded. That's very important as well. Maybe they're including the washer, dryer, refrigerator, microwave sitting on the counter, and the buyer doesn't want them because they bought new and they don't want to move into the property and have to worry about moving those items out. So you would click these blocks and add anything that the buyer wants to exclude from the contract. Okay, let's start to talk about allocation of cost. And I know I'm going quickly because there's a lot to cover. Allocation of cost. Paragraph 10A and 11A talks to them about the natural hazard zone disclosure and tax information. That's where the buyer can see broken down in detail if there's Melleroos or special assessments on the property. It's also going to talk obviously about the high fire hazard area, water inundation areas, earthquake areas, all those, if the proximity to airports, all that information is in the NHD report. And who pays is going to be broken down in this section. You have to mark who the buyer expects to pay. Doesn't mean the seller has to agree when they get the offer, but when you're writing the offer, you place in here who is expected to pay according to the buyer. So customarily, NHD report is paid for by the seller. And additional terms, I would kind of make sure we do in all of our transactions, make sure the environmental report is included. Reason being, the environmental section is where, say you buy a property and there's a flat, beautiful green backyard, and you say to the buyers, oh, I can't wait to see the pool you're going to put in this backyard. And you close escrow and the buyer goes down to the city or the county where they need to get a permit. And they are told there, you can't put a pool there. There's gas transmission lines running through the backyard. You can't dig in that backyard. Well, how would the buyer have known that? It actually would show up in the environmental section of an NHD report. So I would make sure that the environmental report is part of the NHD that the seller supplies to the buyer customarily. And then you can put down and provided by what company. A lot of times you may put your favorite company or seller's choice to get more options available to the seller. They may already have an NHD report by a particular company that they use. Other reports. Here's an area here where you could possibly put termite. If you look at the grid, you're going to notice termite is not mentioned. So how we handle it at our company, we ask for a termite report and clearance if the buyer wants that. And who's to pay for it? Customarily, they ask the seller to. Sometimes the seller will come back and counter, well, we'll both pay for it, we'll split it. Or buyer, you take care of termite, I'm not doing anything. But the option for the buyer to request it, it could be placed in this area. So you could put termite report and clearance, or just if the buyer just wants to report and worry about dealing with the clearance of the termite issues in a request for repair. I kind of look like that as though the horse is out of the barn by that point. They've customarily already said, I'm not paying termite, and they kind of get a little funny when you ask them things, but buyers have the right to ask the seller to do anything. Doesn't mean they have to because they're selling the property as is. But if the buyer wants termite taken care of, this is a good area because it's right under allocation of cost and it describes what the buyer would want. And check the block who is going to pay for it. And if the buyer says, look, I'll take care of all termite issues, you might want to write that in there. You know, termite report and clearance to be taken care of by the buyer, or both. They're splitting it. And if there's any explanation, you can type it in on that line. And I don't know if you know, when you're using zip forms and you want to type something in and it's not allowing you to, if you hit the space bar, it usually turns that area to green, and then you can type anything you want in that section where it will fit. Other reports, maybe they want to report on the roof. Maybe they want to report on a septic system. There is an area where they can request for the septic, but maybe there's something in addition, some type of report that the buyer wants to get, or the seller is going to pay for, they want the seller to pay for, or they'll share the cost with the seller. This is an area where you can write it in. It's kind of an open area where you can write special things in. Smoke alarms, carbon monoxide detector, water heater bracing, Customarily, the buyer would ask the seller to do those, but maybe the buyer wants the price of the house lowered and they'll do and pay for those type things. It allows you to say that the buyer will pay for them. Government required point of sale inspections and reports. Who's to pay for them? This is the buyer putting an offer into the seller. So customarily, the buyer asks the seller to do those things as well. But in the current market we're in, the more the buyer asks for, the worse their offer looks. So we understand that. And there's choices here. The buyer can opt to pay for these items. Government required point of sale and corrective remedial actions. That falls into, like in Los Angeles, the city of Los Angeles, there needs to be a 9A report. There's a lot of items that have to be checked and taken care of. And customarily, buyers ask seller to take care of that. Escrow fees, who's going to pay them? Either the buyer's going to pay them all, the seller's going to pay them all, they're going to both pay them, or a lot of times the most popular answer here is each pay their own fees. And who's the escrow holder going to be? Look under additional terms. Perhaps the buyer has a request for a particular escrow. That's where you type it in. If not, maybe perhaps the good thing to type in there would be seller's choice, make the seller feel better about the buyer's offer. Owner's title insurance policy, once again, customarily, the seller pays for this. And who's the title company going to be? Go over to the right-hand side. Maybe the buyer has a particular title company they want to use, or put in seller's choice. Buyer's lender's title policy is paid for by the buyer, and that customarily it protects the lender that the buyer's borrowing from. County transfer fees. Every county has a transfer fee and tax. It's $1.10 per thousand, and customarily buyers ask seller to pay that. There are certain cities, and we have a list of them. There are certain cities that charge city transfer fees and taxes. One in particular is Pomona. It's an additional $2.20 per thousand to close escrow. So together with the county of 110 and the 220 for the city of Pomona, it's $3.30 combined to close escrow on a house in Pomona. That includes Phillips Ranch. Another area would be Riverside. Theirs is a total of $220. Los Angeles is $4.50 per thousand for the city transfer fee, plus $1.10 for the county. So you should be aware of these things to prepare the buyers to customarily ask the seller to pay for those. HOA fee for prepping their disclosures. That is the seller's responsibility. And the HOA certification fee is the buyer's responsibility. That's if there is a homeowners association. Transfer fees, once again, that's negotiable. Customarily, buyers ask that the seller pay for those. You would check that block. If you don't check these blocks properly, it might fall on the buyer to have to pay for these items. So be very specific when you're filling out the grid. I find that agents are paying more attention to the details in this new purchase contract. HOA transfer fees. Private transfer fees, that's what's happening in the beginning of the 2000s, where you find out if a property has transfer fees, if they put they don't know in the listing. You can find that in the exceptions in the preliminary title report. So customarily, we put down that the sellers to pay those transfer fees, actually, private transfer fees. The private transfer fees are usually for subsequent buyers after the first buyer. And those fees were put on homes usually by the builders. And it's a repeated fee for every buyer that buys the house forever. So if the buyer is going in and asking the seller to pay for it, they just have to remember if there is a transfer fee, they will be the person paying it usually when they sell the property. So remind them you're a buyer now, but you may become a seller. Other fees and costs that would want to be paid for by the seller, I would write it in this area, 3Q16, 3Q17. Maybe they want a roof certification. There's a cost for that. And they could possibly write roof certification, cost and fees to be the seller, possibly when they're writing the offer. Home warranty plan. This was one that I really stuck in my claw there for a while because they took out an area where the options would be placed. They did finally, when the final version of the contract came out, if you see at Q3, Q18, home warranty plan, there's lines there now, and you can actually in zip forms type in information like upgraded plan to include the air conditioning, roof coverage, whatever coverages that the buyer would like them to pay for themselves, or the seller, or both split it. And the cost needs to be in there. They have to spell out what cost it's going to be for the seller or the buyer or both for the plan. And then if the buyer wants to waive the home protection policy and decide later that they'll buy one, they would click the buyer waives home warranty plan. And then issued by, maybe the buyer wants to have the choice because they're the ones going to use the plan. We customarily put the buyer's choice of plan. So know that they did acquiesce, the committee acquiesced. We asked several times that the options be placed there, because a lot of times your either escrow officer or your transaction coordinator is ordering these home protection policies, but they don't know what was negotiated as to what's covered, maybe a pool and a spa, and that affects the cost. And if you look at 10C, the paragraph 10C, that will explain that was not in the old contract and is now in the new contract, that any additional fees for the home protection plan will be covered by the buyer if they did not get the seller to pay any additional cost other than, or if the seller limits, the buyer may come in with this whole big plan that's going to cost $800, and the seller may counter and say maximum cost for the seller for the home protection policy to be $500. It specifies if the buyer wants these other options, the buyer has to pay for them, which is a good thing. It lessens any arguments or issues, but read paragraph 10C, and I'll point that out to you a little later where that's written, and talk to the buyers about that so they're prepared. They may have additional fees for home protection policy if they didn't put enough money in the contract to be paid by the seller, or if the seller comes back and puts a limit on that amount. Then you have other terms. What would go in there? Well, other terms would be perhaps you're related to the buyer. Perhaps you are the buyer. So things like buyer is licensed salesperson or a licensed broker in the state of California representing themselves in the transaction. Maybe the seller is licensed but not using their license. You're going to represent them. Maybe the buyer is licensed. Any of that information that's in the MLS, bring it over into this contract. So for instance, I mentioned, what if the seller's licensed? You should, as the buyer's agent, be writing that information in, one, to avoid a counteroffer, because counteroffers make time, and that means that another offer can come in and beat your offer. But if you're thorough when you're writing your contract and say, hey, seller, all parties are aware, seller is a licensed salesperson not representing themselves in the transaction, or you could put listing agent is also the seller, and then it cuts down anything they have to counter back to you. So you want to write, when you write an offer, you want to write the cleanest offer as you can and gather the information that's coming in from the MLS, because the MLS is not party to this contract, and it does state that in writing in the contract. So other items, other terms would be, and maybe the fence is broken in the backyard, and the buyer looks at you and says, well, certainly they're going to fix that. Well, no, it's an as-is purchase. And then that's explained very explicitly in this contract, what as-is is. Maybe the buyer says, well, no, I want the fence fixed if I'm buying this property. That's where you can put seller to fix the property fence in the backyard prior to close of escrow. So anything that the buyer wants, that's an area where you can write it. If it exceeds the characters, if you're explaining things and exceeds, it will go to a text overflow form. Let me give you a heads up about that text overflow form. To correct anything on it, you have to go back to this area of other terms and go to the text overflow form to fix anything on it that way. You can't just go to the text overflow form and fix things. You have to go through this area. That's just a zip form issue. So let's look in this area up top. This is the only other area that you're actually going to make check blocks on. So the grid's done. Now they're talking to you about property addenda and advisories, property type addenda. Now, if you notice probate manufactured homes here, you no longer have a separate probate contract. You no longer have a separate purchase contract for manufactured homes. It's incorporated as part of this agreement. And the reason why is that it pretty much mirrored the other contract. Why write a whole contract for manufactured homes when it's basically this contract with an additional addendum, and which is called the MHPA. So when you're using, and probate is PAPA, when you're using zip forms and you click these blocks, these forms will automatically add for you, and you complete them and send them with the offer. So once again, they're no longer, don't be looking for a manufactured home purchase contract or a probate. It is actually this contract that you'll check these blocks and get your addendums, and it'll cover the information that's different from the purchase contract that you're using, and it will incorporate it all into one contract for you. Here's where, if there's a tenant for any reason, even if they're saying 5 minutes after there's an acceptance, the TOPA form, which is a new form, and it says should be checked whether current tenants will remain or not. So you have to complete the TOPA form, not just attach it. There's areas in that need to be completed. You would check the block. If you don't have it in your template, it'll add it to your template, your transaction. Tenancy in common purchase addendum and stock cooperative purchase addendum. If they apply, you check those blocks, those documents will be added. Or if it's other, you check the block and add what the other is that you're adding to go with the purchase contract. Other addenda, this agreement is subject to the terms contained in the addenda check below. If there's an addendum, maybe it's other details about the property you're going to do an addendum for. You check the block and number the addendum. All addendums in a transaction need to be numbered. So if the buyer's writing an addendum with the purchase contract, if there's any other addendums, that would be number 2, number 3, number 4. It would subsequently go on from that. Backup offer. Maybe the buyer's writing this offer as a backup. And that once that block's checked, zip forms will add the document to this contract, and you can specify maybe a number of backup that you are. Your backup number 3, you were told by the listing agent, will put that detail in there. If the property has a septic or a well or property monument and it's or propane involved, you must use the SWPI if you expect the seller to do anything about, like investigating it or whatever. You would check the block and send that addendum with the purchase contract. Also, now, if you notice, it's been added, the buyer's intent to exchange, and that's the BXA form. If the buyer's in a 1031 exchange, they would click that, and that form would enter into the transaction, and it would be sent with the offer. Short sales. If it's a short sale, I know it's silly to talk about short sales in this market with everybody building up so much equity, but it'll come. The real estate cyclical, it'll come back around, and that's the block you will check, the SSA. Also, court confirmation. Remember, probate is no longer its own contract, so you're going to deal with perhaps court confirmations with a probate agreement or a court confirmation for a regular sale. You would check that block and add the CCA form. Make sure when you're adding these forms, you look at them. A lot of times they have to be completed up top and referred back to this contract. Put those dates in there, what you're attaching that document to. Seller's intent to exchange. There you go. There's another 1031 reference that wasn't in the old contract. That's the SXA form that would go, and any other documents that you would be adding to the contract. You could check the block and spell out what that is that you're adding. Buyer and seller advisories. Note, all advisories below are provided for reference purposes only and are not intended to be incorporated into this agreement. Interesting. The buyer's investigation advisory, the BIA, comes attached in your bundle of paperwork for the purchase contract. It's already pre-checked. Wire fraud advisory is in your bundle. It's already pre-checked. Fair housing and discrimination advisory, it's checked and attached. By the way, coming soon, I believe after the first of the year, you will be having fair housing and discrimination classes as part of your renewal for your license. The California Consumer Privacy Act advisory, that's the form where if you're collecting information from your clients to sell to other places, you have to disclose that to the buyers and sellers. And that is also attached to the bundle. Now, there's other items that you probably should be using, like the wildfire disaster advisory. That's if you're in or near a wildfire disaster area. Sometimes a property may be near one. I would advise using that. Check the block, add it, send it. Trust advisory if the property is a trust or the buyer's buying in trust. REO advisory is if it's a bank-owned property. Our brokerage, a lot of brokerage and the CAR attorneys highly recommend using the statewide buyer and seller advisory with the contract. So we check that block, send it with the offer. Short sale information advisory, if it's a short sale, you must always attach that. And then probate advisory, once again, it goes along with the probate purchase contract. It would become, if you're checking that item up under property addenda, you also probably would use the probate advisory. Okay, so we're getting into the paragraphs now. And if you notice, I'll just give you an example. Initial deposit, buyer shall deliver directly to the escrow holder if a method other than wire transfer is specified in paragraph 3D1. So if you go back to 3D1, it's going to ask about the initial deposit. So as you see, the grid is referring to the paragraph refers back to the grid, which I think is excellent. Like I say, you never feel lost in this contract. You always know where to go and where to go for additional information. Increased deposit, once again, if you see in this paragraph, the DID will be used, which is the delivery of the increased deposit. Now, it's no longer receipt for increased deposit. So it refers to that new form. And you can find information about that in 3D2. Retention of deposit. This is what I want to talk to you a little bit about, because a lot was made of the retention portion of a lot of agents are writing non-refundable clauses. And we want to remind you, and it states in this bold paragraph, that if the remedy is being changed from other than what was agreed upon in the contract and during the contract, or if the buyer's going in and say, take my deposit if I don't buy, you really should be consulting a qualified California real estate attorney to do the verbiage for those documents. So pay attention to what this contract's telling you, and it will refer back to 3D2 regarding the increased deposit or retention of a deposit. So once again, pay attention to what they're telling you. This used to be in the liquidated damage area. It has now been moved to the initial and increased deposit area. All cash offers. Once again, you can go back to paragraph 3A, and where it says it's okay, if an all cash offer is specified in paragraph 3A in the grid, no loan is needed to purchase the property. This agreement is not contingent on the buyers obtaining a loan. Okay. Then it says buyer shall, within the time specified in 3H1, deliver written verification of the funds sufficient for the purchase price and closing cost. So it's referring you to different areas of the grid for different paragraphs here. Let's move up a little bit, Laura. The loan, first loan amount, it's right there on page 1, how much it's going to be in 3E1. Remember, the grid doesn't put the 3 in front of it, but when you're referring to it, perhaps in a counteroffer, you want to go ahead and refer to 3E1, for example, rather than just E1 from the grid. Additional financing amount, that would be referred to once again in 3E2. Buyer's loan status. This is a good one. Buyer authorizes seller and seller's authorized agent to contact the buyer's lender to determine the status of the buyer's loan specified in paragraph 3E, or any alternate loan buyer, any alternate financing buyer pursues, whether or not it is a contingency of the agreement. So it doesn't even have to be a contingency. They could release the loan contingency and still be able to check on the loan with the lender, the listing side. Notwithstanding seller's agreement that buyer may obtain FHA or VA financing, seller has no obligation to pay or satisfy any or all lender requirements unless agreed in writing. Remember, that used to be on page 1 of the purchase contract in the old days. Now it's in the section under loans here. And also, remember, they did away with the FVAC form. So any lender requirements have to be handled in the request for repair. There's a section in the request for repair that would deal with that. Balance of the purchase price, down payment, paragraph 3F, including all cash funds, to be deposited with the escrow holder pursuant to the escrow holder's instructions. Well, it reverts, remember, to wire transfer. So if the buyer wants to save money, and we hear a lot of times the buyers do want to save money, they may drive a check over to escrow. You better put that in the offer and override the facts that it's to be wired in. Okay, and then watch the third-party checks as well. There may be a form that needs to be signed. Limits on credits to buyers. I get my agents come in after a negotiation for a request for repairs, and they'll say, well, instead of repairs, the seller wants to give the buyer $3,000 towards any repairs that may need to be done. They don't want to deal with handymen, and they don't want to, well, that's all well and good, but I can't answer that question. You have to read this paragraph, and it says that the lender may have limits on what the buyer may be credited by the seller. So if you upfront negotiated closing cost for the buyer, now all of a sudden the seller wants to give them $3,000 more, it may exceed what the lender wants. So I always turn it back over to the agent to talk to the lender and see if the lender would be okay with that credit. And if there is a credit, remember, don't just negotiate it between the buyers and the sellers and put the paperwork in the file. You have to notify the lender, because the lender is going to have to change some documents around perhaps, and escrow has to be aware of the credit. So don't forget those items when you're working with changing things after the original agreement. Always keep the lender and the escrow in the loop. Additional financing terms, verification of the down payment and the closing cost. Once again, it's referring you back to paragraph 3H2 and paragraph 6B. Verification of loan application. That's an interesting one. People don't talk much about the loan application, but that has to be done quickly by the buyer. And it refers you back to 3H3 if you want more information about when the buyer has to work on their loan application. A lot of times I'll hear 10, 12 days in, the buyer says to their agent, well, we're still shopping. Well, you need to apply for your loan and get that process moving pretty quickly in a transaction. Buyer stated financing. If the buyer comes in and says, I'm paying all cash, and then decides to ask the seller, may I get a loan? This paragraph refers to the fact that they may go ahead and get a loan at no cost or time to the seller, but they can't use that loan as a way to get out of the contract because they took the seller off the market with a cash offer. So if the loan doesn't work out, they have to revert back to the cash. And that's what this paragraph says. Closing and possession. This used to be a section all its own. And now they've moved in the as is information in this section. Let me look at my notes real quick here because a lot changed in this area. Okay. There is a sample letter in CAR library regarding if things are left in properties. So you might want to utilize that. It's in zip forms under the attorney's letters that they've written for you. The as is in its present condition as of the date of acceptance. And that was always in the contract, but it goes into more detail about that. And items that may be left in the property. If items are not removed when the possession is delivered to the buyer, all items shall be deemed abandoned. Now, if this is a rental, it would be different because the law is different for landlord and tenants. So don't just because the purchase contract says this and a tenant moves out of a property, say, well, that deemed abandoned. That's not necessarily so. The landlord must store the items left by a tenant for 20 days, but not in this situation where it's a seller and buyer. The items can be considered as abandoned. Buyer, after first delivering to the seller notice to remove the items within 3 days, may pay to have such items removed or disposed of and may bring legal action as per this agreement to receive reasonable cost from the seller. So that's interesting if you read that regarding items left in a property. Buyers strongly advised to conduct investigations of the entire property in order to determine its present condition. And this is where it falls where buyers are going in and releasing contingencies to inspect a property or to check a property for any defects. Now, all of a sudden, they're being told it's strongly advised to conduct investigations of the entire property to determine its present condition. Sellers and agents may not be aware of all the defects affecting the property or other factors that the buyer considers important. What we think is one thing, but what the buyer thinks is quite another. Then property improvements may not be built according to code or in compliance with current law or have had all the required permits issued or finalized. So this information was in the old contract. Things have been moved around. Sellers remaining in the property, we've already discussed that when we came to that in the grid. Do use your SIPs if the seller's staying anytime after close of escrow, and indicate that. There's even an area on the SIP form that they can charge. Maybe the first 3 days will be free, and then there's an additional 5 days, 7 days, 10 days that they can stay. Maybe they're having a house built and their house isn't quite ready and they need to rent back from the buyer. There's where the SIP could fall in. If it's over 29 days, you once again have to use the residential lease after sale form. And that needs to usually be approved by the lender if the buyer checked that they're going to occupy the property after close. Let me see. We go down to move up, close of escrow. Seller signs any warranties. That's already been in the contract. That's down the bottom of the page, Laura, so we can move it up a little bit. Okay, stop right there. Okay. Any keys, passwords, codes, any means to operate any locks, mailboxes, security systems, alarm, home automation systems, intranet. They've added all the new stuff that people are leaving as well, that they want left. Garage door openers, all items in either paragraph 3P or paragraph 9. So you see they're referring back and forth now to the different paragraphs in grid. The properties of condominium are located in a common interest development. Sellers shall be responsible for securing or providing any such items for association amenities, facilities, and access. Buyer may be required to pay a deposit to the homeowners association to obtain keys to accessible HOA facilities. So a problem arises sometimes in the contracts, and I'm glad they spelled it out like this, that sometimes the seller will say, I have to give you all the keys. I have to give. Well, when the seller moved into a condominium, they probably put deposits on these keys for the HOA and the maybe a tennis court, mailbox. They put these deposits down. Well, when they leave, they want to turn the keys in and get the money back. And it states right there that the buyer has to pay for those deposits to get those keys. Then a lot of times it's people are upset at the end. Well, I didn't get the pool key. I didn't get the, well, if you're reading the contract and understand it, you're going to tell the buyer up front that they're going to have to obtain the facility keys by putting down a deposit. And then that issue is not an issue anymore, especially at the close of escrow. You want everything to be happy, and flow through. Contingencies and removal of contingencies. The agreement is, unless otherwise specified in paragraph 3L1 or the attached CR form, contingent upon the buyer obtaining the loan specified. If contingent, and buyer shall act diligently and in good faith to obtain the designated loan. If there is no appraisal contingency or the appraisal contingency has been waived or removed, then failure of the property to appraise at the purchase price does not entitle the buyer to exercise the cancellation right pursuant to the loan contingency. If buyer is otherwise qualified for the specified loan and the buyer is able to satisfy the lender's non-appraisal conditions for closing the loan. Now, that's the new business, the new nature of our beast right now we're dealing with is falling into this contract now. So it's specifically targeting people coming in and releasing appraisal contingencies. The buyer has to understand they can't use the appraisal contingency to get, or the appraisal to get out of the contract any longer. But what confusion is happening, though, is when a buyer does not have an appraisal contingency, the seller thinks they're not going to get an appraisal. Well, that's not true. The buyer has the right to get the appraisal, and the seller needs to leave the property available for all investigations and including the appraisal. And their argument would be, well, there's not supposed to be an appraisal. That's not what the argument is. What the argument is the appraisal is not going to be used as for the buyer to cancel. They're going to bring the difference in and or negotiate with the seller, whatever they've decided in the contract. So I know there's been a lot of people thinking, oh, they waived the investigation contingency, so they're not going to get, or they can't get an investigation. Or, well, no, that's not the case. They need to do their investigations. Obviously, they just can't use it to cancel. So hopefully everybody understands that. I did ask at the beginning if anybody had any questions. Laura, do you want to take a minute now and see? I know I've covered a ton of information and I know I'm going fast, but I have to because I have to cram it in to the next 35 minutes to finish.
So nobody's put anything in the chat. I don't know if anybody has a question they want to unmute themselves and ask the question.
I do have a question.
Sure. Hi, Sheila.
Hi, Linda. Okay, just one quick question in regards to the retention of deposit. Is that taking place of liquidated damages?
No, liquidated damages is separate.
Okay.
Yeah, you're still going to see the liquidated damage paragraph. It's just they took that part and put it in a different area of the contract. It's all part of liquidated damages. Liquidated damages, if it's initialed by the parties, obviously anything over 3% would be returned to the buyer. Mm-hmm. And then what we were talking about at the beginning with the increased deposit, if the seller would have a claim against the buyer's deposit for whatever reason, if they have a claim against them, if that DID is not signed when the extra money goes in for an increased deposit, the seller can only go after the buyer for the original deposit. So say $5,000 now, in 2 weeks, I'll give you another $5,000 towards my earnest money. Mm-hmm. If they don't sign the DID, the deposit, for the deposit. The seller can only go after them for the original $5,000. And of course, to go after them, when I say go after them, that means never tell a seller, oh, you're going to get their deposit, or never tell a buyer, you'll get your deposit back, don't worry. No, there is a worry. They are in an escrow. There's a possibility anything could happen. And a judgment by an arbitrator or a court could be anything, or small claims. We can't predict. So the best language to use would be, you may have a claim against the deposit.
Okay.
I hope that answers that. Just that portion is pulled out and put in a different section, but there is still liquidated damages. Absolutely.
And one more question. So is, I mean, AVID form, is that something still a part of, transactions?
Oh, good question. Your AVID, actually, the law states, the legislators chose on page 3 of the TDS, at a minimum, the legislators want to put the agents to put down what they diligently visually see in a property. Smart CAR attorneys created a form that can be used. We found that there were less lawsuits in areas where brokers were creating forms to assist with this, which it became the AVID. I've been on the forum on forms for years, and I've watched a lot of these forms be developed, and it's so helpful. So a lot of brokers require an AVID because it's pretty specific and it does help the agent do their duty. But legislative wise, the 3rd page of the TDS is the only place that the legislators say that the agent has to fill out. We, like I say, smart brokers are requiring the AVID be completed and attached. Now, the TDS is not complete until the agent's visual inspection disclosure is complete.
Okay.
Whether it be on page 3 or an AVID, the TDS is not complete till both agents, and neither agent are ever exempt from completing that. Right?
Yeah.
And also section 1 of the TDS, something has to be checked. More than likely, it's going to be no substitute disclosures. But those 2 items are very important to, and of course, the seller completing all the information on the form, page 1 and 2, where they fill it out in their hand. And that completes a TDS. And that has to be to the buyer, complete by day 7 after acceptance.
Okay. All right. Thank you.
Hope I helped.
Yes, that helped.
All right. Anybody else? Question? You can unmute yourself and ask, or raise your hand, or type it into chat.
Hi, Linda.
Yes.
This is Suzette Baker with Coldwell Banker, and I have
Hi,
2
Suzette.
questions.
Sure.
Back on section 3, Q14, I heard you're talking about the transfer fees on the HOA. As far as the transfer fees, who should pay? I know you covered the CERT, the prep, but I didn't hear what you said on the 3rd part on the transfer fees.
Okay, let's get back to what section are you in?
Q14, 3?
Q14.
Yes.
All right, HOA transfer fees, that's up for grabs.
Okay. That's what I thought.
Yeah,
What page is that on?
it's on page 3. Customarily, Suzette, customarily,
Yes.
the buyer, when they write the offer, will ask that the seller pay those transfer fees.
Correct. Okay.
Yeah,
And I
it's
just thought
not-
maybe
yeah,
something had changed. Okay.
that's
I'm sorry.
otherwise-
And
Yeah, go ahead.
oh, I'm sorry, one more question. Okay. What if you are a listing agent, you receive an offer and the RPA states that they're going to live in it, and during the process you find out they actually lied, that they're purchasing it as an investor? As a listing agent, what is your obligation, or do you have one?
You know, I kind of would talk to the agent about that and how we instruct our agents, and what the CAR attorneys have said, that if a buyer looks at you and says, you know what, I'm going to put down, and I told the lender I'm going to live in it, but I'm really not, but I want the greatest rate and I want less money down. So, people are serving time in prison for this. So it is lender fraud, and I don't look good in stripes, nor do I look good in orange. So I am not going to be doing that. And with the advice of the attorneys, when we've asked over the years, being a CAR director, I had the fortune of hearing this straight from the horse's mouths at CAR. They said, run as fast as you can. But I see your question is, what if you're on the listing side? I actually would I would have your manager or broker talk to their manager or broker, and I would put it in writing that it was discovered and you made that effort.
Okay. All right. Thank you. You've been
Welcome.
very informative.
Thank you. Thank you.
You're
Glad you're
welcome.
liking it. Anybody else? Great questions. How's it going so far? Everybody okay? Yes, Caroline.
I have a question regarding to the escrow fees. If I check the box that saying that, the escrow fees should be shared between, buyers and seller like equally. But how can I, make sure that, and also there's another checkbox saying that, each party, pays their own, escrow fees.
Mhm.
How can I make sure that, the escrow fees will be, equally, shared by both parties?
Okay, so that's a good question because both and each pay their own could be two different things. You are correct.
Yes.
It could be two different things. So put down what the buyer is willing to do. So is the buyer
Mhm.
willing to pay perhaps some of the seller's cost? Because if it's both, it probably would be divided down the middle. But I would always check, and how we do our template would be each pay their own fees. And now you don't have an issue with the buyer worrying, well, did I pay something that I didn't have to pay that went towards the seller? Maybe a buyer's willing to do that. But your question is valid and that's correct. And it's why it's spelled out specifically that way instead of just buyer, seller, or each pay their own. The both is there because there could be a possibility of one paying the other's portion of fees.
Mm.
Does that make sense? So if you
Yeah,
want to
that would-
protect the buyer, I would put each pay their own. That means the buyer will only be paying escrow fees for what they've spent.
Mm-hmm. Yes, but I heard that, some escrow companies that they offer, lower rates. I'm just talking about, not other, I'm talking just about the escrow fees, not anything, related to, let's say, recordings or messenger fees. I'm not talking about those. I'm just talking about, strictly the escrow fees. And I heard that, some escrow, they charge, seller a lower escrow fees and then
Right.
charge more, to buyer.
Right, right. I understand what you're saying. And well, let's give an example. What if your sister works over at the escrow company? Does she necessarily have to give the buyer, you're the seller, and does she necessarily have to give the buyer a discount because she's giving you one?
No.
So there you go.
Oh, I see.
That's
I got
where,
your point.
that's why the buyer would click, I'm only going to pay my fees. I don't care
Okay.
what they're paying. They may be paying more because the escrow may have done some work for them prior to putting the house on the market. And I've seen this happen. And the escrow says, don't worry about it. I'll just collect it when I charge you the escrow fee. I'll tag it onto that. So if you're putting both, that fee may get collected, into what the buyer is paying. So
Okay.
to protect the buyer, I would just put, I'm only going to pay my fees. I don't care
Okay.
what you're charging, maybe more or less.
I see. Okay, good to know. Thank you so much.
You're welcome. Good question. Anybody else?
So you got about 30 minutes left, Linda.
Okay, let's pick it up again.
I wouldn't rush you, but I have another class at 1.
No problem. No problem. Where are we? Let's get back to where we were.
Okay.
Do you remember?
I think we were on page 6.
Okay,
Does this look right?
sure, we'll go with it.
Okay.
And let me see the rest of the page.
I think this is actually where we left
Yeah.
off.
Yeah, I think we took care of all of that, investigation of property, all of that. Because I talked a lot about these items, that's why I'm skimming over them in the, but I want to make sure you understand where things are and feel comfortable with where the items are. Title, once again, let me get over to that area myself. We're on page 7 now, right? I didn't miss anything.
6.
6, okay. Just didn't want to miss anything from my notes. Here comes my favorite part. Notices to perform. Please, once again, we are we are in a transaction here that has timelines and things need to be done on time. Like I explained earlier, tell the buyers, tell the sellers up front to follow the contract. Sometimes people can't do everything in a timely fashion and expect maybe to get a request for an extension of time. And if somebody's not performing, please let me send a notice to perform on your behalf. Maybe they forgot, maybe something slipped through the cracks. Maybe they're thinking about canceling. Wouldn't you want to know today rather than 2 weeks from now, letting things slide and slide and slide? Because if say the release of contingencies is day 17, it's left that way in the contract. Did you know that a notice to perform can go out on day 15? And I would highly recommend that. Maybe there's another buyer waiting in the wings. Maybe this buyer is going to cancel for some reason. They're disgruntled because of the request for repair and response, whatever. And they're thinking about canceling. Now you have another buyer waiting that maybe would net the seller more money. Put that notice to perform on day 15. It's a 2-day minimum notice. So on day 17, on day 18, the seller can make a decision. Do I want to stay and give this buyer more time to decide? Or do I want to send a cancellation? Hey, you're not performing on time according to the contract. But you got to remember, you got to be following all the timelines, not just 1 or 2. So you have to watch. Escrow will give you these timelines. I know our TC gives our timelines right up front. By this date, this has to happen. This date, you are the responsible parties here as the agents to be watching this contract in detail and to make sure people are doing what they're supposed to be doing. Don't just, oh, they're nice people. We don't want to interrupt them. We don't want to upset them because somebody's going to be upset with you if they don't get the opportunity to close escrow on time. The delays could be that something a lot of times we worry about delays and think, oh my gosh, the other party's going to be so upset. Maybe they need a little more time as well. I find that sometimes request for extension of time helps the other party. And we worry that, oh, they'll get mad and they'll want to cancel or get upset with us. No, know the contract. You're the smart ones. You're in the class learning what the contract says and where it says it. And make sure that everybody understands up front. And then you're not with the seller. Well, now we're going to put a notice of to perform on the buyer. And the seller's like, what are you, crazy? Don't chase my buyer away. That's what is perceived to be happening, but that's not what is going on. So please use the notices to perform, use the extension of time addendums. If you know your client can't do something in a timely fashion, according to the timeline in the contract, use an extension of time request. It'll look real good if you're in front of a court or if you're in front of a arbitrator that's going to make a decision. Who's going to pay for what? And it's usually the agent that ends up paying, unfortunately. So we're going to talk now about items included and excluded like we did. We can move it up a little bit, Laura. Note to the buyer and the seller, and I keep repeating this, items listed as included or excluded in the MLS, the flyers, the marketing materials, disclosures, are not in the purchase price or excluded from the sale unless specifically mentioned in the contract. So read the MLS before you write the contract on behalf of the buyer and put all that information that needs to be stated and talk to the buyer about things they want included, talk to them about the things they want excluded. This deals with all those items here, and it goes back and forth between the grid. And remember the big section where it's stated where you can check off things that are going to be included and an area where you can exclude items. But what I want to bring your attention to is 9B. I had an incident with a window covering situation and ended up calling the CAR attorneys before I even got my question out. The attorney was telling me, yes, the curtains are included. And the other side of our transaction was saying the curtains were on the rod, so therefore they were personal property. That is not true. And I love the fact when I saw this new purchase contract come out, if you look at existing electrical, mechanical, you know, it mentions all the things, the gas logs, the grates, the solar power systems. These all are things that are included in the contract. And it talks about the window and door screens, awnings, shutters, window coverings, and I love this, they've added, which includes the blinds, the curtains, the drapery, the shutters, or any other materials that cover any portion of the window. So when you're talking to sellers listing their properties, tell them anything that's attached to your windows do remain unless you reserve them or exclude them, and they're able to do that. And then the buyer would accept or reject that, or they would negotiate. Any attached floor coverings, TV antennas, satellite dishes, air coolers, conditioners. They talk about, even back in the grid in 3P, they talk about, how about plants? Things that are planted in the yard, yeah, they stay unless they're reserved and excluded from the sale. So note, if seller does not intend to include any item specified as being included above because it's not owned by the seller, whether placed on the property or by the agent, a stager, or any other third party, the item should be listed as being excluded in paragraph 3P, or excluded by the seller in a counter offer. So no, a lot of that, once again, they brought this contract into today, and a lot of people are getting their properties staged. And then they may be negotiating some items, but they have to understand the staged items don't belong to the seller and can't be left at the property, but it has to be on the listing agent to remind the seller we need to reserve these items or take them out, exclude them from the sale. It talks about security systems. Lots of people now are getting the home automation and security systems. It's detailed here what has to happen. Non-dedicated devices, the smart home, smart and security system and control devices. Is it staying? Is it going? If it's attached, does it stay? All of these things need to be negotiated. How about leased and liened items? You know, we have the water softener system. We have, like we mentioned earlier, the solar panels. All of that needs to be negotiated, and everybody has to understand, well, what's staying and what's going. Okay. This section up here, items excluded from the sale, the bracket now go with the TV. Remember, in the current contract, it says that if they're in a family room and there's this big screen TV attached to the wall, and the buyer says to the agent, oh, well, it's attached to the house, so that stays, right? Well, our answer before was, no, the TV goes because it's attached to a bracket. The bracket has to stay. And if the buyer wants the bracket removed, the seller would have to fix the wall, not necessarily paint it, fix the wall. Well, look what the new contract says. The new contract says that the bracket now goes with the TV. And it says, unless otherwise specified in paragraph 3P1, brackets attached to walls, floors, or ceilings for any such component, furniture, or item will be removed, and the holes or other damage shall be repaired, but not painted. Don't you think that's something you need to mention to the sellers when you list the property? When you take your TV, you have to patch the wall where you took the bracket off, because a lot of times it's leaving big holes, and it becomes issues for the buyers and the sellers that they're arguing after close of escrow. We don't want that to happen. Allocation of cost, the buyer is willing and able to ask for anything. It is an as-is contract. As a result of the request, the seller has some options. They can say no. They can say, yes, I'll do everything the buyer asks. They can do, I'll do some things, not others. Maybe as number 4, perhaps they'll credit some money towards closing costs if the lender allows and that amount hasn't been exceeded. Or what's number 5? I like to put my hand up and teach when I'm teaching real estate. I like to tell them it's no, yes, I'll do some things, not others. I will give you credit because I don't want to deal with handymen. number 5 is in this paragraph, it says the seller doesn't even have to respond. And why doesn't the seller have to respond? Because it's an as-is contract. So buyers have to understand that. A lot of times we'll hear buyers say, well, we don't want to release contingencies because the seller hasn't responded to our request for repair. Well, courtesy would tell you they should respond. However, do they have to? No, because the house was sold as is. So if they're not responding, they did answer. The answer is no. So if everybody understands that, also now we're talking about reinspection fees. Remember, we talked about it in 10B1. If items are not there that should be there upon inspection, somebody's got to pay a reinspect fee. And that's customarily going to be the seller if it's items like the smoke detector, water heater bracing, and the carbon monoxide detectors. Let's see, home warranty. Can we get down to that real quick? I love the fact that they did add that the buyer is advised to investigate the coverages to determine what's suitable for them. Okay, if the buyer waives the purchase of the home warranty, buyer may still buy the home warranty plan at the buyer's expense prior to close of escrow. But it also says buyers shall choose the coverages regardless of any optional coverages indicated of the home warranty plan. And the buyer shall pay any cost of that plan chosen by the buyer that exceeds the amount allocated to the seller in paragraph 3Q18. That was not in the old contract. It is now. Now that's settled. So point that out to the buyer when you're writing the contract with them. If you don't reserve enough money and the seller won't pay enough money to cover your home warranty, the balance of what is due is going to be charged to you. Let's see. Lead-based paint disclosure has changed its name. It's one of the statutory forms that is included in the purchase contract. Anything that's law would be the TDS. Then the it used to be the FLD form. It is now currently called the lead-based paint disclosure, which is what it should have been called, and it is now the LPD form. So if the house is older than 1978, not if it's built in 78, if it's older than 78, there will be an LPD form now. It'll be used in your transactions. It'll come from the seller to the buyer. We can move on. I'm just going to touch on highlights now because we're running out of time. Home hardening, defensible space. We would recommend that you use these documents because your properties you're listing and the buyers buying are probably near, in California, it might be near an area, and they're addendums, not just advisories or disclosures. If it's used, the fire hardening is used as a disclosure. In other words, it is in a high fire hazard area. The seller must answer the questions on the form. If it's not and being used as an advisory, you can check a block where it says it's not in a high fire hazard area. However, we are giving you this as an advisory and you check that block that applies. Let's see. Remember, everybody, in the withholding taxes, which is section 11H. Remember, by day 7, the buyer has to receive either a QS, which is the escrow collecting the information, including the social security numbers from the sellers, and be a qualified substitute for the sellers regarding FERP to foreign investor, or the AS form has to be complete with all the information completed on it. If one or the other isn't done, the buyer should be contacting escrow to withhold taxes. And it's pretty quick that they get the form completed properly when that happens. Megan's Law, don't do that investigation yourself. Give the buyers the meganslaw.ca.gov website to check. Keep going. We have touched on a lot of this already. Condominium and development, those forms we talked about, the sellers have to pay for obtaining the documents and the buyer has to pay for their certification. No material facts have to be disclosed to the buyers. That's always been. Talks about investigation with property matters affecting the property. Buyer needs to really do general inspections and lead inspections, and all the inspections. I would really caution against them releasing contingencies for inspections. You do know that the seller has to leave the utilities on, completely on all the utilities through the possession of the buyer, and the possession of the buyer is determined in the contract. So if they're staying past close of escrow, it would be through that extension or close of escrow plus 3 days. All utilities must remain on. Let's see where we are. We're not going to miss anything. They did add a section in 13 regarding avoiding money laundering. There's some forms that need to be filled out. And the geographic targeting order, that's added to the in 13E. If you see that on the second line there, that's been added to the contract now. Obviously, the bold down the bottom, manner of taking title, significant legal and tax consequences. Please do not tell them how to take title. Let's see. Time periods. We can move up, Laura. Time period, section 14. And once again, seller has to deliver documents, and it's the timing is now in the grid. It used to be in the paragraph, now it's in the grid. Also, buyer review of documents, repair request, contingency removal or cancellation. Once again, the timing for that is in the grid. It's customarily by day 17. Seller's right to cancel. Sellers don't get a whole lot right to cancel, but there we are with the notices again we're talking about in section 14C1. Seller has the right regarding buyer's contingencies, but also if the buyer's not performing, they need to give them the notice for the buyer to perform. And it turns around the same way. What if the seller has a contingency to find another property, a replacement property by day 17, and they haven't done, day 17 comes and goes and the contingency isn't released? Well, the buyer shouldn't be spending any money on that property for appraisal or for investigations, inspections, until that contingency that the seller found a replacement is completed. And you can address that on that form for allowing the seller to have a contingency from seller to buyer regarding finding another property. So make sure those forms are utilized in your transactions. Goes into details why a seller can cancel, why a buyer can cancel. Please read these contracts. Let's see, final condition. We can go to the next page, Laura. At the walkthrough, the final verification, item number 16. Remember, it's 5 days prior to close. Reason being, it's 5 days prior to close. It's usually when loan docs arrive in escrow. Buyers usually want to see the property again and make sure the repairs that were supposed to be done, agreed upon in writing, if any, are checked and made sure they're done. We do get sellers asking us, when should I do these repairs? I agreed on day 10, I'm going to do all these repairs for the buyer. When do I need to do them? We would recommend not until the buyer releases contingencies in writing, okay, and prior to the 5 days prior to close for the final verification. So there's your timeline there. Reason being, if they go ahead and agree and start doing repairs, maybe the next buyer, if this buyer falls out, maybe the next buyer may not want those same repairs, may want other repairs. Now you have a frustrated seller on your hand. So wait till the contingencies are released and prior to final verification, because final verification is where the seller has to show the buyer they did what they were supposed to do. And by the way, give receipts. And that's in section 15 under repairs. It states specifically there that obtain invoices and paid receipts for the repairs performed by others. They should be passed on to the buyer. Other things at the walkthrough you want to remember to discuss is transfer of keys, how that will take place, and transfer of utilities. Don't have anything shut off, have it transferred into the buyer's name. And you can give everybody phone numbers and timing when you are at the walkthrough. That's a great time to do all those things. Okay, let's go to the descriptions, and that's going to be on page 13. I just want to point out on page 13, a lot of things we just went back, right? Stop, go up, back up the other page. There you go. Keep going to the top. There we go, right there. If you want to know what days after is, if you want to know what as is, if you want to know what they mean by when they speak of the agreement, there's the instance, there's the definitions right there. What's close of escrow? How do you count the days? There it is right there. So it's on page 13 in your purchase contract. Please take the time to read every word of these contracts. You shouldn't be writing them if you don't know where things are. Next page, Laura, please. We're going to go to liquidated damages. And notice that this section now is a little smaller than it used to be because a paragraph was moved to another area of the contract. Buyers and sellers still initial this. Everybody understands that mediation is very important to explain to the buyers and the sellers, because before they arbitrate or go to court, whatever is decided, they need to agree to mediate. If they don't agree to mediate, that's fine too, but warn them they will not, if they win the dispute, would not get attorney's fees. So you have to mediate in order to gain attorney's fees. I just want to real quickly before we end, go to page 15. There's your arbitration section. And where I'm seeing a lot of issues, stop right there, is, and I love this, right above the buyer's signature, if you see 32C, the RPA has 16 pages, buyer acknowledged receipt of, and has read and understands every page and all the attachments that make up this agreement. I know that's a taxing thing, but they're buying something that they've never spent more money on in their lives. And this is really, really a legal contract, legal and binding contract. Now, if the buyers are entity buyers, you have to check the block. If they're buying in a trust, if they're buying as part of an LLC, a corporation, a partnership, remember, we've done away with the RCSD. It's no longer required if this portion of the contract is properly filled out, and it has to be addressed. Who's the legal signer? And then it goes on to the section where the legal signer would sign as the buyer. Now go a little bit up on the page, Laura. There we go. Acceptance. We're getting a lot of pushback from listing agents saying the buyer's agent should be filling out the entity for the sellers. No, we don't have that information available to us, how the seller's selling the property. So if a seller's countering, the listing agent has to check the seller counter or the seller backup offer. And if it's a seller that's selling out of a trust, an LLC, a probate, a partnership, an attorney, power of attorney, other entity, they have to check that block and they have to fill the information in. Then the seller signs, the person that's able to sign, and move up a little more. Okay, and if there's more than one signer, you can add if there's more than area for more signers, they can go ahead and say, stop right there a moment, Laura. Offer not accepted. Remember that used to say rejected. It's just softer now. It says offer not accepted. And that would be initialed by the seller if they're not accepting the offer and the date they're not accepting it. Okay, next page and last page. Broker section, where I'm having issues seeing is that the cover sheet is not auto-plating the email address and the text number, which technically is the cell number of the agent on either side. So the selling agent, buyer's agent, has to add this information, and all this information needs to be complete. It does have an area there. If it's more than one agent from the same brokerage, you can do the AAA form, or if it's more than one firm representing. And we've had that as well with share buyers, share sellers with other agencies. It accommodates you using the ABA attached form. Once again, the bottom, if the buyer's brokerage is filled out, make sure the seller's brokerage is filled out as well, and their email and text number. You can get that from the multiple listing service. The other thing I want to point out is that if your presentation of offer, and this is a big one, this is an NAR rule, all offers, it's been a law, all offers need to be presented, but NAR has created a rule that if the agent will not tell you when the offer was presented or give you any evidence that it was, they must give your, either have seller's initial this and when the offer was presented, or the agent and when it was presented. If not, they can be sanctioned by National Association of Realtors. So know that this is a ethics violation if they're not responding to you regarding, and talk to your broker or manager if you're not the broker or manager regarding if this isn't coming back. Because a lot of times buyers get mad and leave us because of something somebody else did. Like didn't respond to the offer because the offer was never presented. And that's information you need to pass on to the buyer. Don't want you to lose your buyers. Anybody questions? I believe I got through that. Sure.
Linda, I do, in regards to the last two things that you covered,
Yes.
offer not accepted and presentation of offer. Asking question to all of you, how often is it even completed?
It's upon request usually.
Okay.
Yeah, and you can request it on every transaction. Hey, by the way, this isn't only the new rule coming out. Another rule is that the listing side can request you prove you gave a counteroffer to the buyer now. That's a new rule coming out. And if that is requested, you have to show proof that the buyer did receive the counteroffer.
Okay.
Interesting, huh?
I know.
Complaints.
I don't know how it's, because I definitely am not getting it. You just have to call the agents and they say, oh, the seller decided on another offer.
Yeah,
but and nothing from them.
And you can request this page in writing and explain to them if you don't provide it, you are going against NAR Code of Ethics. And the information regarding that is in section 4 above. So if we could go up to the top of this page, Laura, please. Right there, presentation of offer pursuant to the National Association of Realtors Standard of Practice 1-7. If the buyer's agent makes a written request, seller's agent shall confirm in writing that this offer has been presented to the seller. So utilize your code of ethics and you would highlight that and send it to them. And they would be violating the code of ethics. And we have methods to take care of situations like that.
Okay, so what is the form? Just curious. What is the form we have to ask for, to send?
This is it. Go down the bottom of the page, Laura. They have to send this back to you with either.
No, but as a buyer, what do you send them saying that have they presented the offer? What is?
Oh, you can send an email, just a request.
Oh, okay.
Keep a request in your file. Yeah, and I wouldn't just call on the phone. I would put everything you're doing in writing and keep it in your file.
Okay.
Absolutely. But if you don't hear anything back, ask that they either give you the rejection, which was now didn't accept your offer, or prove the presentation. And don't make accusations at them. Just say, my buyer is requesting proof that the offer was indeed presented.
Okay.
Okay. Hope that helps.
Yep. Thank you. You're
welcome. Okay, page 16, designated electronic delivery. Do I put my email and phone? Yes. Good question. Yes. And if there's an alternate, see, because we only have access to what's in the multiple listing usually for the other agent. So maybe there's another email that's better for them for you to use. They can put that alternate as well. Anybody else? Questions? I must have done pretty good.
You were very thorough.
Good.
You were very, very thorough.
Hi, excuse me, I have a question really quick.
Sure.
Under the escrow holder acknowledgement, I know there's something new there where it says, where is it? Escrow holder is advised by blank that the date of acceptance of this agreement is, they're getting this information from the listing agent or the buyer's agent?
No, I know, my escrow officer called me immediately when she saw that. She says, wait a minute. And she had an issue with it. So I don't know if they're going to change that or if escrows, but to the best of their knowledge, see, remember, you have to supply the escrow with the fully executed contract and any, and the information's there. But my escrow officer had an issue with that. And notice on the bottom of that section, I apologize for not mentioning it, but they have to check, are they Department of Financial Protection and Innovation? Are they Department of Insurance or Department of Real Estate that their escrow falls under? So they have to give that information.
Okay, I was wondering because I had an offer accepted. I received it yesterday about 4:30. But it was date, which was the 24th, but it was the acceptance date was the 23rd. So I was wondering, what are they going to show as the acceptance date?
When was the final person who signed, whether the last seller or the last buyer?
The seller signed the buyer's counter offer. The date is the 23rd.
Okay.
We received it the 24th.
Doesn't matter when you received it. Never go by the date you received it, because you could be on a cruise and not receive it for 10 days.
Well, that's when they sent it, because they were still waiting for cancellation of previous escrow.
It doesn't matter. It's the date of acceptance on the documents.
Okay, so then
or else every transaction would be, well, I wonder when it was finally received by somebody. No, it's always the date of the final acceptance. And actually it refers to that in the contract here.
Yeah.
The date of the last person who's to sign, that's the date. You don't add to, well, I never got it back or things like that. Yeah.
That's why I was wondering when I saw the escrow, when it's saying in there, the escrow holder is advised the date of acceptance, what that date is. And I was wondering, I wonder if it's because of that, a situation like that. It was signed, but it was never sent to the buyer's agent.
Yeah. Unfortunately, delivery is important. However, it's as of that signature, or like I say, dates would be all over the place. How would you know? It has to be a date certain, and the only date certain you would have would be at the final acceptance, when there's a complete meeting of the minds. Does that help?
Thank you.
I know people are bowing out. I know you have other engagements to go to, but if you want me to stay a moment and answer any other questions, be glad to.
Well, just a reminder that this class will be found. I did record it. And so if you want to go back and look at it again, it will be on the Tri-Counties website. I will share with you so that you can see it on the screen where it actually is. So do you see, oh wait, here we go. So do you see this page?
Mm-hmm.
So this is the Tri-Counties website. It's on the education page. And this is where I keep all the videos for all the classes and events that we have done. You can also find it on the Tri-Counties YouTube page. We've got everything here that we've done, all the classes. You can go back and look at Linda's class that she did with John Giardinelli, which is 6 hours long, and that's super detailed if that's what you want. There's a few different classes here for the, this one is done by Ed Estes at Mount SAC. So we have a few different options for you to go back and look. So please do that.
Yeah, and remember, I'm coming at it from the practitioner like you are. Ed Estes and John Giardinelli famously, and they're fabulous attorneys, are going at it from the legal side, which fascinates me because we're in it. But I like to hear the legal side of it too, and that's how I could give so much information as well, because I talk to them a lot. And Laura and I are on the Real Estate Advisory Committee for Ed Estes at Mount SAC. So we keep abreast of what's going on over there with the teachings that they're doing at Mount SAC for the purchase contract and the other documents.
Yeah.
Good job, Linda.
Oh, thanks, Lynn.
Yeah.
Thank you very much.
Thank you, Linda and Laura. It was
You're
great.
welcome.
Thank you. Welcome, everybody. Hopefully you learned something and you successfully write your contracts and get them accepted. Thanks, everybody.
Bye, everyone.
Bye.
Take care.